All right, well, welcome to CMMC Unacknowledged, where we answer the unanswered questions that were asked during the monthly CMMC-AB Town Hall meetings. My name is Todd Stanton. I'm the Regional Sales Manager for all things CMMC at Etactics. And as always, I'm joined by Ty Wittenberg. Ty is the Senior Information Assurance Manager at Ray & Associates. Welcome, Ty.
Hey, thanks, Todd.
All right, so our question for today, continuing on the theme of CUI. Are all for official use only, which is FOUO, markings treated as CUI?
So, do I get to give a history lesson first?
Absolutely.
So, for official use only, FOUO is a old legacy marking for what is now controlled unclassified information. Didn't necessarily fall in the bucket of secret or top secret, but not information that we just wanted to be wide open in the public. So, the CUI program replaced that. If you are a organization that has been doing business in the space and you might have a procurement order where, documentation still has FOUO on it. Should it be treated as CUI? My recommendation and my answer to you is yes. So if you've got it in paper form in your environment, I would definitely recommend that you put some sort of cover sheet on it or rubber stamping it with CUI. But that marking FOUO should no longer be coming out in documentation, and that really should have been replaced probably around 2012, right, when they started having these conversations around CUI. And so if you have it in your environment and you're still using it relevant to contracts that you're engaged in, yes, you should treat it as CUI.
But it shouldn't be prescribed anymore. You shouldn't be getting new documents that were generated last month from your contractor with those types of markings anymore, correct?
You shouldn't. The funny part about me saying that, though, is, sometimes folks use boilerplate stamping and they haven't gone back through. And just like marketing material, whether it be on the web or handouts that you give, that cadence of double checking it may have been missed. But if you're listening to this podcast with us, then yes, you should not be receiving it that way anymore. But if you do, which potentially could be happening, treat it as CUI.
So are you familiar with Bob Metzger? He's an attorney who's pretty prominent in talking about CUI and the CMMC space. He came out and go ahead.
Go ahead. No, I'm listening.
So he said that FOUO is a marking that people use when they don't want to go through the trouble of finding out which distribution statement really applies. So
I think that, yeah.
I
love attorney speak.
I take his comment is like, echoes your sentiment that it may still be used, it shouldn't be, right? But it may still be used. So in its absence or in its evolution is a distribution statement. Is that really what should be marked as opposed to the FOUO, like distribution statement B or F, or is that what they're using today?
I can only speak to the examples that I've seen. And no, that is not how it's being marked. It is a litany list of everything from FOU, the Federal Acquisition Regulations, some of the, I think it's IT-MIL markings, and then ITAR. I mean, it is, if you think of alphabet soup on documentation that could just cover every single of the bases that might expose you to if you didn't mark it correctly, that's what's happening. There is no clarity around the different distributions.
Okay, interesting. And so from my research, the answer to that question would have been no, in terms of is all FOUO a category or considered CUI? And the literature I read said that the owner of these legacy documents, so the government, if they're the ones that marked it, they're the ones that would really need to review it to determine if it meets the CUI requirements. So the explanation was FOUO may be more general than the CUI categories. And so you may have some documents that are marked. So not everything marked as FOUO would be considered CUI, but it really wasn't up to the contractor, the person who's holding that, to determine that. It's the information owner, the person who marked it initially, that would really need to make that determination to look at the categories of CUI that DAR has created to determine whether or not this piece of information that was marked FOUO fits into one of those categories and therefore should be remarked as CUI.
Yeah. So that is a great point. I've seen that conversation as well too. My thought process is no different than if you're in an organization that has a human resources department, a medium to large organization. Typically, your human resources rules around your behavior and is typically stronger than the law, right, to protect the organization because of the uncertainty and clarity. And so all that to be said is I would err on the side of treating it as a CUI, because in the majority of cases where I've seen it, that's been the case, that it has been CUI. You clearly know when you look at federal contract information. So I guess if it is FOUO, but it's only contract information, you should know how to treat it. But look, it says the people who marked it originally, but then there's also, NARA, the National Archives. They have a mandatory training, not only for those folks that are in the executive branch, but also for anybody that touches that type of controlled unclassified or federal contract information. And clearly it states that who's ever in possession of it as well too is responsible for protecting and marking it accordingly, right? So I err on the side of being overprotective in that particular case. And if I'm wrong, the only thing that has happened there is that you've lumped some information into a category that isn't, and hopefully you get some information of when it's been made public knowledge, and then you can move it out of that or destroy it accordingly and not have to worry about that anymore.
I think your approach is the right approach to, safeguard it as if it is CUI. There's a chance that it is, probably a better than not chance that it is CUI, but that determination of what distribution statement it really should have, what category of CUI it is, would really be up to the owner of that information. And so I guess, you're covering your bases by telling your clients, like, protect it as if it is CUI, correct?
Yeah, for sure, right? Unless we sit down and do a full-on review together of it and we find that it has no technical diagrams in it or drawings or specs, and it's just federal contract information, which, it'll probably have contract number or something like that in there as well too for the documentation, then we would treat it accordingly. But look, let's be very honest. If you're a small shop, do you have an administrator or somebody or a procurement person that's going through every single document and reading the every single line? And I think you and I have discussed this before. We as a culture have become so numb to boilerplates, end user level agreements, the EULAs, that we just click yes or whatever, that it's better to be safe than sorry.
Well, I think here's where, it comes into play from, my understanding of how some organizations are preparing for CMMC. You may have certain people who obviously handle CUI and they're, using a specific email function that has all the requirements of NIST 800-171 baked into it. And then you have other members of the organization that are kind of de-scoped and, they shouldn't be getting CUI. So if, a contractor up the stream is sending an email to somebody that's not within that CUI enclave, and it's got documents that are marked for official use only, but we don't think it's CUI. At that point, does it beg the question of following the strategy you talked about in a previous meeting, going back to that contractor and clarifying, hey, what you're sending me with these FOUO markings, is this something that I should be treating as CUI? And if so, maybe you need to send it to this email instead, because this is not the appropriate system that I have set up to receive that type of information. Yes,
I would agree with that. I would go one step further that, most folks are not utilizing some form of medium assurance communication or medium assurance tokenized communication between themselves and those vendors. So, if you're sharing documentation, hopefully your prime or you yourself have some sort of secure portal or secure sharing that gives you a secure link where the person has to register and log in order to be able to access that information. Because look, emailing and playing in the open is always a gamble, and then it may not be malicious, but user error internally for that still constitutes an incident of compromise. So the more you can reduce your exposure, whether it be marked as FOUO or whatever, or CUI, the better you are.
Understood. So if I see something FOUO, then it's treated as CUI. If I have questions, maybe go to that contractor that's sending it to me and ask for clarification there.
For sure. And look, if you are a shop that is doing your due diligence and like you have somebody in procurement that is fully vetting the entire contract, the procurement agreement, reading through if you have a boilerplate stamp on it and you identify that clearly this is federal contract information, you have that confidence because you've been doing that for quite some time. You still have to treat it and secure it as federal contract information. It does not require those additional controls that the CMMC Level 2 or 800-171 require for that. But at least do your due diligence. To answer your question, yes.
Okay. Well, let's leave it there. Appreciate your response on this question. As always, thank you for your time.
Well, it was awesome chatting with you. Thank you.
Thanks, Ty.